Hello and welcome to ThePrint. I am Disha Vashisht. Earlier this week, the Parliament cleared the Repealing and Amending Bill of 2025, which deletes Section 213 of the Indian Succession Act 1925, eliminating the requirement of mandatory probate for certain bills. This 100-year-old provision has forced families in India's biggest cities, such as Chennai, Kolkata, Mumbai, to go to court before acting on a will. Let us understand how this bill will change things on the ground. What is probate? Probate is a court certification that establishes a will as genuine. It legally authorizes the executor to administer the deceased's estate. In a probate proceeding, the court examines whether the will was validly executed and if the testator had the mental capacity to make the will. This is done to determine if the document is genuine. So far, probate has been central to succession battles in India. Until now, in what were the presidency towns under the British, that is Mumbai, Chennai, Kolkata, certain wills were unenforceable unless they first passed through a probate proceeding. Mandatory probate applied only to wills made by Hindus, Buddhists, Sikhs, Jains and Parsis, not to Indian Muslims or Christians. The requirement applied only if the will was executed within the original civil jurisdiction of the high courts at Calcutta, Madras or Bombay, or dealt with immovable property in these cities. Recognizing the discriminatory nature of this British-era law, the amendment removes this dual distinction that has long been in conflict with succession laws in India, turning probate from a mandatory exercise to an optional one. The bill also proposes amendments to Section 370. This section prohibited courts from granting a succession certificate for any debt or security, example shares, debentures, bank deposits, if the right to it was required to be established by obtaining a mandatory probate or letters of administration. Residents of erstwhile presidency towns will now be able to and can approach authorities such as land registries and banks directly with a will and will no longer need a court order to prove ownership. The bill has been cleared by both the Rajya Sabha and the Lok Sabha. Once the President gives her assent and the bill is notified in the National Gazette, beneficiaries and executors will no longer need probate to establish rights under a will. This change will shape the way inheritance disputes unfold going ahead, ending a system that so far has tied enforceability of wills to factors such as geography and religion. By bringing about a uniform and efficient procedure, making the execution of wills more feasible for the families of the testator. While this change will make the process of succession easier by reducing costs and delays, it comes with a caveat. While no longer mandatory, probate may still be an advisable exercise, keeping in mind that without probate, a will's validity is not conclusively established upfront and may be challenged later, even after assets are distributed. Another important thing to note is the prospective nature of the change. With a savings clause included in the bill, rights already accrued or liabilities incurred under the old law remain untouched. Existing probates remain valid and ongoing probate cases currently pending before the high courts will continue unaffected. Thank you for watching. Please follow ThePrint for more such updates.